Hey everybody, I'm Damon Moore, and I want to talk to you about 7 of the biggest mistakes that people make when they want to start their own limited liability company, or also known as an LLC, or start their own corporation. So before I talk about these 7 common mistakes, I'm going to tell you why it matters to me. I've been practicing law since 2005. I taught a class in minority entrepreneurship and civil rights law at the University of Texas at El Paso. I have law offices in 3 states. I'm licensed to practice law in multiple states. I was a C-level executive for a company that has more than 50 employees and several $1 million in annual revenues. At my office, my law office, we like to say that we help influencers, entertainers, and entrepreneurs bring their dreams to life. So please believe me when I say I have worked with a lot of entrepreneurs and a lot of want-to-be entrepreneurs. I meet a lot of entrepreneurs in the beginning stages of their ventures. Some of those entrepreneurs will meet with me and then decide that they're going to file their paperwork and start their business without hiring any lawyer, or hiring me, or without hiring any lawyer for that matter. And the rationale is that they can file the paperwork themselves, or that's what they believe. They say, hey, I can file the paperwork myself, so I'm going to save the money that I would spend on hiring an attorney, and I'm going to use that money for some other thing. I also meet a lot of entrepreneurs and company directors after they've been sued by someone. And the person who's suing them is often suing them in their individual capacity. And it's in that moment that those people discover that they're personally at risk because the company did not follow the proper formalities. In the legal world, we call that piercing the corporate veil. And getting your veil pierced is a pretty big deal. It means that even if you're part of a corporation or part of an LLC, under the right circumstances, you can be sued personally and lose your personal assets. So I got tired of seeing people make stupid mistakes. And some of you are just not going to hire a lawyer as long as you think you can save some money by forming your own entity. So I'm going to tell you some of the mistakes that you need to avoid if you plan to file your own entity formation documents. Mistake number 1 is a failure to create bylaws or an operating agreement. There's more to creating an entity than just filing formation documents at the Secretary of State's office. You're typically supposed to create a document that explains how the entity is going to do certain things. And that document is called bylaws if you're forming a corporation, or it's called an operating agreement if you are forming, or if the entity that you form is a limited liability company. And it doesn't matter if you are a corporation or an LLC. I'm sorry, it doesn't matter if your corporation or your LLC has one person or more than one person. An operating document needs to be made. It's shocking to me how many times I see people get sued and they do not have bylaws or an operating agreement, or they have a document of like that, but it's copy pasted from something on the internet. Get your own document. Mistake number 2 is bad corporate record keeping. Certain decisions that an entity makes must be recorded in the company's minutes, or the company's meeting minutes. But if you don't have meetings and keep a corporate records book, then you will struggle to provide records that show the decisions that have been made. That's a major problem if you're sued and you have to demonstrate why you or the directors made the decisions that you made. Let me explain how it plays out in a trial. When an opposing party sues you, they name your company, and then they name you in your individual capacity. We could debate about whether they're supposed to do that or they're not supposed to do that. It's just a thing. And it's something that you have to deal with, especially when you are a small company. And so when they file the suit, then they'll serve something on you that they call discovery. And discovery is kind of this umbrella term for a series of documents that they serve on you that require you to provide certain information to them. All too often, the requested documents include your formation documents, your meeting minutes, and your bylaws or operating documents. When you're not able to produce those documents, you increase the likelihood that the opposing party will be able to argue that you should not be able to use the limited liability protections that you're supposed to get through that entity that you formed. Mistake number 3 is what we call commingling funds. Sometimes people will use the entity's business account to pay for their personal items. This is a big no-no. If you are in a lawsuit and your opponent can show that you used the business account to pay for your personal items, then that person, that opposing party may be able to convince a judge that you should use or you should have to pay for your business items with your personal account if you lose the case. Mistake number 4 is failure to hold an annual meeting and follow formalities. In some states, you're required to hold an annual meeting, and your failure to hold an annual meeting can have a negative impact on your company. Unfortunately, a lot of people have no idea whether their state requires that they hold an annual meeting. Number 5, choosing the wrong lawyer. The decision to choose a business lawyer is one of the more important decisions that any entrepreneur can make. And a lot of entrepreneurs make the wrong choice. In many instances, the entrepreneur avoids choosing a lawyer because the entrepreneur wants to save money. But in other instances, the entrepreneur hires a business lawyer who does not know anything about business. Sure, the lawyer may know business law, and the lawyer may even own his own business or her own business. But that does not mean that the lawyer is an entrepreneur or that the lawyer understands the world of entrepreneurs or that the lawyer understands the life cycle of your particular business and how it relates to the services that the lawyer is providing. Lawyers with true business knowledge and contacts are worth the fees that they charge. Mistake number 6 is creating the wrong entity. For example, a limited liability company when you should have created a corporation. A lot of do-it-yourself entrepreneurs create the wrong entity. They create a corporation when they should be creating a limited liability company, or they create a limited liability company when they should be creating a corporation. The best way to make sure that you make the right choice when it comes to the entity is to meet with a lawyer and talk about your plan and your goals for business. And number 7 is that they choose the wrong name. A lot of people choose business names that someone else is using. In many instances, this can be avoided by doing a business name search at the local level. Or if you plan to create a company that does business outside of the state or outside of the state in which your company does business, you can avoid using someone else's name by doing a trademark search with the trademark office. So those are just 7 mistakes that I see people make when they're starting their limited liability company or their corporation without using a lawyer. Let's talk about some next steps. Be sure to press the like button if you're watching this now or you're watching a replay. Be sure to subscribe. Ask questions in the comments. If I begin to see questions repeat themselves, then I may make videos that address some of the questions that I see in the comments. Tool up.